Out of California, federalized Trump National Guard because senior Judge Charles Breyer says so in a new preliminary injunction that's just been issued today in breaking news. Charles Breyer, senior status judge up in San Francisco, siding with Governor Gavin Newsom and Attorney General Rob Bonta against the Trump administration, finding that a new attempt by Pete Hegseth.
Get out of California. That's what a federal judge just told Donald Trump's federalized National Guard in a stunning ruling that dropped today. And I mean, this literally just happened. Breaking news that changes everything about Trump's authoritarian power grab in California. Senior Judge Charles Breyer up in San Francisco just sided with Governor Gavin Newsom and Attorney General Rob Bonta against the Trump administration. And the language in this preliminary injunction is absolutely scorching. Let me tell you what just went down, because this is huge. Judge Breyer found that Pete Hegseth, the embattled defense secretary, who's currently drowning in controversy over those boat killings, made a new attempt back in October to claim there was violence or civil disturbance on California streets, particularly in Los Angeles, that prevented the execution of federal law. And Judge Breyer essentially called this what it is: a lie, complete fabrication, not true. And because it's not true, Donald Trump no longer has the power under a statute called Section 12,406 to continue federalizing the National Guard. By the way, I am trying to do my best to gather all the information I can for you and share it with you. Please leave your likes and comments, and I would be grateful if you subscribed. Let's continue. Now, let me explain why this matters so much and why the timing of this ruling is critical. We've always feared that what Trump was really trying to do was keep the National Guard under federal control on California streets through the midterms so he could interfere with elections. That's the real end game here. Not protecting anyone, not maintaining order, but having a federally controlled force in the largest Democratic state in the country right as voters head to the polls. And Judge Breyer is clearly onto this scheme. He went back and looked at new filings from California and determined that this federal takeover must end immediately. What Trump did was take over California's state militia in violation of basic principles of federalism, in violation of the 10th Amendment, which reserves powers to the states. And as of today, Judge Breyer says that ends. The National Guard, being federalized by Trump, seized from state control, and turned into essentially a national police force, that's over according to this ruling. Let me read you directly from Judge Breyer's order, because the language is powerful and the reasoning is exactly what we need judges to be doing right now. I'm going to start at the end with his actual order, and then we'll work backwards through his analysis. The court has granted the plaintiff's motion for preliminary injunction. Defendants, that's Trump and his administration, are temporarily enjoined from deploying members of the California National Guard in Los Angeles. Defendants are directed to return control of the California National Guard to Governor Newsom. Now, the court stays this order until Monday, which gives Trump time to run to the Ninth Circuit Court of Appeals, which you know he's absolutely going to do. He's already done it twice before with Judge Breyer's rulings. But for now, there's also a nominal bond in place. And most importantly, there's this incredibly powerful language from Judge Breyer about what's really happening here. And for those who don't know, Charles Breyer is the older brother of Stephen Breyer, who served on the United States Supreme Court until his retirement. Very smart family. Being an excellent judge and justice clearly runs in the Breyer family. Here's what Judge Charles Breyer says right at the beginning on page 1 of his new order, and listen to how direct this is. The founders designed our government to be a system of checks and balances. Defendants, however, make clear the only check they want is a blank one. Boom. Right out of the gate, Judge Breyer is calling out the Trump administration for trying to operate with zero accountability and unlimited power. He continues, 6 months after they first federalized the California National Guard, defendants still retained control over approximately 300 guardsmen, despite no evidence that execution of federal law is impeded in any way, let alone significantly. And then he drops this bombshell. What's more, defendants have sent California guardsmen into other states, effectively creating a national police force made up of state troops. This is exactly what the founders feared and tried to prevent. a standing national army under presidential control that could be deployed anywhere to enforce the will of one person rather than the democratic will of the people. Judge Breyer even quotes the Federalist Papers, specifically number 51 by James Madison, one of our founding fathers. He writes, "To what expedient then shall we finally resort for maintaining in practice the necessary partition of power among the several departments as laid down in the Constitution? The only answer that can be given is that all these exterior provisions are found to be inadequate. The defect must be supplied by so contriving the interior structure of the government as that its several constituent parts may, by their mutual relations, be the means of keeping each other in their proper places." This is constitutional law at its finest. This is a judge who understands that the entire structure of American government depends on different branches and different levels of government checking each other's power. When one branch or one level tries to grab unlimited authority, the others have to push back. That's not partisan politics. That's the foundational design of our system. Judge Breyer is also clearly shocked by certain legal positions the Trump administration has been taking. On page 10 of the order, he addresses their argument that courts don't have the power to review any actions by the president under Section 12,406, and his response is devastating. He writes that defendants are trying to circumvent the scope of the statute by characterizing ongoing orders as extensions of federalization, which they argue are outside the statute's reach and therefore beyond judicial review. Then Judge Breyer reveals something truly alarming. At the motion hearing, defendants confirm their position that after an initial federalization, all extensions are utterly unreviewable by the courts forever. Let me repeat that. Forever. The Trump administration argued in federal court that once the president federalizes a state National Guard unit, he can keep them under federal control forever with zero judicial oversight. Judge Breyer's response to this, that is shocking, and he's right to be shocked. He writes, adopting this interpretation would permit a president to create a perpetual police force comprised of state troops so long as they were first federalized lawfully. Such a scenario would validate the founders' widespread fear of a national standing army, which they believed posed an intolerable threat to individual liberty and to the sovereignty of the separate states. This is a judge who understands history and constitutional design. The founders were terrified of exactly this scenario, where a president could command a permanent military force to enforce his will across the country. That's why they created federalism, why they gave states control over their own militias, why they wrote the 10th Amendment reserving powers to the states. And Trump is trying to blow right through all of those protections. Now let's talk about Judge Breyer and the Ninth Circuit for a moment, because the legal landscape here is complex. The Supreme Court hasn't yet ruled on one key aspect of National Guard mobilization by the president. They have a Seventh Circuit appeal from Illinois that's been sitting with them, and this new order from Judge Breyer might finally motivate them to issue a ruling about what Section 12,406 actually means. The statute says the president can federalize state National Guards when regular forces can't execute the laws. But what are regular forces? Judge Breyer originally interpreted that as meaning ordinary security forces, including local law enforcement combined with federal law enforcement, but not the military. However, there's another interpretation that regular forces includes the armed forces. So under that reading, the president would have to use local law enforcement first, then federal law enforcement, then the actual military, and only as a last resort could he tap state National Guard units. And that's the question sitting with the Supreme Court. But here's the brilliant part of Judge Breyer's analysis. He says, it doesn't matter which interpretation is correct, because under either reading, there's no evidence that Los Angeles or any part of California is currently in such a state of rebellion or civil disturbance that any level of law enforcement can't function properly. There's no emergency. There's no ongoing crisis. There's nothing that justifies continued federal control of California's National Guard. Judge Breyer even admits he might have been wrong in his earlier interpretation about what regular forces means, which shows intellectual honesty you rarely see from judges. But he says under either interpretation, the facts on the ground simply don't support continued federalization. There's plenty of evidence observed by multiple judges that California is not experiencing anything close to the kind of breakdown in order that would justify this extraordinary federal takeover. In footnote 20 on page 20, Judge Breyer addresses the Trump administration's argument that past violence, even from months or years before, is enough to justify current deployment of federalized National Guard. And he completely dismantles this. He writes that there must be a colorable basis to conclude, based on past events, that there was an ongoing inability to execute the law at the time of federalization. Common sense must guide that inquiry. He cites other judges who've asked similar questions. Could the president rely solely on civil unrest in Portland in 2020 to justify deploying federal troops at a Portland ICE facility in 2025? If this statute was in effect at the founding and President Washington had called up militia to deal with the Whiskey Rebellion, could those troops remain federalized forever even after the rebellion ended with no judicial review? The absurdity of the Trump administration's position becomes crystal clear when you frame it this way. So what happens next? Judge Breyer has basically invited Trump to appeal to the Ninth Circuit. The stay until Monday gives them time to file their emergency request. A new 3-judge panel will be appointed, and here's where things get interesting and potentially concerning. 1/3 of Ninth Circuit judges are Trump appointees, and we've seen repeatedly that bad things happen when 2 Trump appointees end up on the same panel. Just yesterday, there was a ruling from the D.C. Court of Appeals where 2 Trump judges ended up on what's usually a relatively moderate and liberal bench. Judges Rao and Katsas ruled in favor of Pete Hegseth to allow throwing transgender soldiers out of the military. So the composition of whatever 3-judge panel gets this case matters enormously. That's a lottery we're about to participate in, and it could determine whether Judge Breyer's ruling stands or gets overturned. There's going to be an emergency request for a stay by Monday. We're going to see a battle at the appellate court level based on the record developed by Judge Breyer. And then this will almost certainly end up at the Supreme Court, which has been sitting on that Illinois case about Section 12,406 for over a month now. Maybe this California ruling will finally get their attention and force them to provide clarity about how this statute works. Although honestly, the Supreme Court has been pretty busy helping Donald Trump and bending over backwards to accommodate his every request, so who knows if they'll actually do their job on this issue. But eventually they'll have to address it, especially with a ruling this significant coming out of the Ninth Circuit. Let me put this in broader context because what's happening in California isn't isolated. This is part of a pattern of Trump trying to centralize power, to break down the boundaries between federal and state authority, to create enforcement mechanisms that answer only to him rather than to democratic institutions or legal constraints. We're seeing it with attempts to control local law enforcement. We're seeing it with threats to withhold federal funding from states and cities that don't comply with his demands. We're seeing it with efforts to politicize the military and federal agencies. And the National Guard takeover in California is maybe the most brazen example. Trump saw the largest Democratic state in the country, a state that's been a consistent check on his power, and he decided to seize control of their state military force. The excuse was civil unrest and protests, but those largely ended months ago. There's no ongoing emergency. There's no breakdown in law and order. There's just Trump wanting to maintain control through the midterm elections. Think about what that means. If the president can federalize state National Guards based on protests that happened 6 months ago, keep them under federal control indefinitely with no judicial review, and deploy them to other states to create a national police force, then federalism is dead. State sovereignty is meaningless. The 10th Amendment becomes a dead letter. Everything the founders designed to prevent centralized tyranny gets swept away. And that's exactly what Judge Breyer understood and what his ruling pushes back against. He's saying, no, the Constitution still means something. The separation between federal and state power still matters. Presidents don't get blank checks to do whatever they want just because they declare an emergency. Courts still have the authority to review these actions and determine whether they're lawful. The Trump administration's position that extensions of federalization are unreviewable by courts forever is genuinely shocking, as Judge Breyer said. That's not how American government works. That's not what the Constitution allows. That's the kind of unchecked executive power you see in authoritarian regimes, not democratic republics with separation of powers and judicial review. I want to emphasize how important Attorney General Rob Bonta's work has been on this case. He's been fighting this federal takeover from the beginning, filing motions, presenting evidence, making constitutional arguments that have now been vindicated by Judge Breyer's ruling. This is a huge victory for California and for the rule of law, and it shows why state attorneys general are such a crucial check on federal overreach. When the Trump administration tries to grab power illegally, when they make arguments that shock federal judges with their audacity, it takes state officials willing to fight back in court. Bonta did that. Newsom supported it, and Judge Breyer agreed with them. That's the system working as designed, different levels of government checking each other's power. Now we wait to see what happens at the Ninth Circuit. Trump will absolutely appeal. He'll probably get a stay of Judge Breyer's order pending that appeal, which means California National Guard might remain under federal control while the legal battle continues. And depending on what 3 judges get assigned to the panel, we might see this ruling upheld or reversed. But even if it gets reversed at the Ninth Circuit, this is going to the Supreme Court eventually. And at some point, the Supreme Court is going to have to address these fundamental questions about presidential power, about federalization of state national guards, about what emergencies justify federal takeover and for how long. They can't avoid it forever, especially with Judge Breyer's ruling laying out the constitutional stakes so clearly. The founders designed our government to be a system of checks and balances, but the Trump administration wants only a blank check. That line from Judge Breyer captures everything about this moment in American politics. We have a president who views any limitation on his power as illegitimate, who believes he should be able to do whatever he wants without oversight or accountability, who's willing to shred constitutional principles if they get in his way. And the only thing standing between that vision of unlimited executive authority and the preservation of American constitutional democracy is judges like Charles Breyer, who understand what the founders were trying to protect and are willing to enforce those protections, even when it means standing up to a president. The federalization of California's National Guard was always about more than just having troops in Los Angeles. It was a test case for how far Trump could push federal power into state sovereignty. It was practice for potentially doing the same thing in other states, particularly Democratic states that resist his agenda. It was laying groundwork for having a national police force under presidential control that could be deployed anywhere. Judge Breyer saw through it. He looked at the facts, looked at the law, looked at the Constitution, and said, no, this stops here. You don't get to create a permanent presidential police force made of state troops. You don't get to ignore the 10th Amendment and federalism. You don't get to operate beyond judicial review. The checks and balances still exist, and courts will enforce them. That's what this ruling represents. It's a reassertion of constitutional limits on executive power. It's a defense of state sovereignty and federalism. It's a rejection of the Trump administration's most authoritarian impulses. And it's a reminder that even when things look darkest, even when it seems like democratic institutions are crumbling, there are still judges who will do their duty and enforce the law. The National Guard needs to leave California under federal orders. Control needs to return to Governor Newsom where it belongs, and the Trump administration needs to accept that they can't just seize state military forces indefinitely based on protests that happened half a year ago. That's what Judge Breyer ruled today. Whether it stands depends on the Ninth Circuit and ultimately the Supreme Court. But for now, at least one federal judge has said clearly that the Constitution still means something and presidents are not kings. 300 guardsmen still under federal control 6 months after any justification disappeared, sent to other states to create a national police force, held indefinitely with the administration arguing courts can never review these decisions. That's not America. That's not what the founders designed. That's not what the Constitution allows. And Judge Charles Breyer just said so in language that should make every American proud that there are still judges willing to stand up for our founding principles. The battle continues. Appeals are coming. The Ninth Circuit will weigh in. The Supreme Court eventually has to address this. But today was a victory for federalism, for the 10th Amendment, for judicial review, for checks and balances, and for the principle that presidents are bound by law just like everyone else. Get out of California, federalized National Guard. That's what Judge Breyer said, and that's what the Constitution requires.